welcome to another episode of Talking Politics here at The Hindu with me, Nistula Hebbar, where we unpack the news making the headlines in domestic politics. This week, campaigning wrapped up for the Himachal Pradesh Assembly polls, and polling too got done. In Gujarat, the BJP announced its list of candidates with a massive cut in sitting MLAs and weaning away senior faces like former Chief Minister Vijay Rupani and Deputy Chief Minister Nitin Patel from electoral politics and rewarding a large number of Congress turncoats who had joined the BJP recently. The cycles of electoral politics notwithstanding, this episode of Talking Politics will be looking at the Supreme Court's judgment and its upholding of the quota for the economically weaker sections, EWS, within the general category. And basically, this is a judgment which has implications both for the Constitution of India and also going ahead, politics of social justice and identity. Now, talking about all of this, what was the background of the EWS judgment? Well, the Constitution of India allows for reservations in jobs and educational institutions for socially and educationally backward sections of society. And reservations have been extended to scheduled castes, scheduled tribes, and later to the other backward classes. The BJP-led government in 2019 brought in the EWS quota to provide reservations in jobs and higher education to economically weaker sections of society. And this was not necessarily those within the scheduled caste, scheduled tribes, and other backward classes, but within the 50% of general category seats in educational and other government jobs, which apply to general category people. This is separate from the SC, ST, and OBC. The Constitutional 103rd Amendment Act 2019 was passed by both houses of Parliament, and it enabled both the central and the state governments to provide reservations to the economically weaker sections. It also altered two fundamental rights as a result. The amendments, Article 15(6) and 16(6), calls for improving the status of economically weaker group, and the eligibility criterion was defined as those with an annual family income of less than 8 lakhs. Basically, it meant that not just reservations for those who have been historically suppressed and are socially and educationally backward, but also people who are just basically economically weaker sections of society without that historic oppression tag being attached to them, they would be eligible for reservations. This could mean even upper caste people among poorer sections of society who could get a 10% reservation within the 50% quota of general category seats. Interestingly, while the 103rd Constitutional Amendment was winding its way through Parliament, in the Lok Sabha, only the Indian Union Muslim League and the All India Majlis-e-Ittihadul Muslimin opposed this amendment, while in the Rajya Sabha, the Rashtriya Janata Dal, the IUML again, and the DMK opposed it very strongly. All other parties were in support of this constitutional amendment. So therefore, that says a lot about the state of politics at the moment, and us asserting that we are in a kind of a post-Mandal sort of situation in domestic politics at the moment. While the Parliament passed the bills, there were concerns about how the 10% sub-quota within the 50% general category seats will affect admissions to higher education, and whether it will cut into the seats available overall, especially for students of the SC, ST, OBC, and the socio and economic backward communities. And therefore, the Education Ministry over the next 2 years has made a move to increase the number of seats available in educational institutions, government educational institutions. Now, once this bill was passed, what happened? Well, shortly after the passage of the Constitutional Amendment Bill, several petitions were filed challenging the EWS, the economically weaker section quota. Now, what were the arguments of the petitioners in their legal challenges? Well, one argument was that the basic structure of the Constitution had been violated, as This amendment sought to reserve seats solely on the basis of economic backwardness rather than social and economic backwardness, and that reservations had been enshrined in the constitution to address historic oppression, and it was not a tool for getting economic equality between various caste and communities, but actually to address historic oppression through caste society. And secondly, the argument was that the EWS quota was discriminatory as it applied to a category that kept out SC, ST, and OBCs. I mean, there are poor people there also, so they could also have availed of this purely economic criteria to get reservations through this subquota. But they were kept out. It was only for general category poor. And thirdly, that this particular amendment breached the earlier Supreme Court judgment in the Indira Sawhney case of 1992 that reservation quotas cannot exceed 50% of the total seats available. Now, government argued back. It said that reservations should be that reservations made on the basis of economically weaker sections does not violate the basic structure of the Constitution, as it promoted equality, and that SC and SC and OBCs were not being discriminated against as they were already recipients of reservations, and that the EWS quota had been carved out of the general category seats available and did not at all have anything to do with the SC, ST, and OBC reserved seats. On the 50% cap issue, they said that it only related to existing reservations and not to the new EWS quota. So, based on these arguments, there were three questions that the Supreme Court had to decide on. A. Can reservations be allotted solely on the basis of economic criteria? B. Can the EWS, the economically weaker sections reservation, exclude other groups like SC, ST, OBC? So, for example, if I'm an SC or an ST candidate and I'm extremely poor, can I be eligible? Can I be excluded from basically only looking at my poor status or my poverty rather than my caste or my community entitlements and apply through that other category? Am I to be excluded altogether, or can I also do the same? This was one question again. The second question that the Supreme Court had to decide on. Now the third question, C. Does the economically weaker section reservation breach the 50% limit set by the Supreme Court? Now this matter was heard by a 5-judge bench of former Chief Justice U. Lalit, Justice Dinesh Maheshwari, Justice Ravindra Bhatt, Justice Bela Trivedi, and Justice J.B. Pardiwala. And a majority view of 3 judges, that is Justice Maheshwari, Justice Trivedi, and Justice Pardiwala, upheld the EWS quota, while the minority view of 2 judges, Justice Bhatt and former Chief Justice U. Lalit, was not to do so. Former Chief Justice of India U. Lalit was serving his last day in the court, and the minority opinion was authored by Justice Bhatt. Now, these are some of the details of how that went down. So now let's look at what the majority view and the minority view of the judges had to say on these 3 important questions that were raised by this case. Now, the question number 1, whether reservation on the sole basis of economic criteria violates the basic structure of the Constitution. Majority view was that it does not violate the basic structure of the Constitution. Reservation was being seen as an instrument of affirmative action by the state to ensure an all-inclusive march towards the goal of an egalitarian society. Minority view of Justice Bhatt and Justice Lalit held that reservation is designed as a powerful tool to enable equal opportunity and equal access. Introducing economic basis for reservation as a new criterion is permissible, yet the othering of socially and educationally disadvantaged classes, including SC, ST, and OBCs, on the grounds of pre-existing 50% reservation will amount to heaping injustice based on their past disability. The second question that the answers were being sought to was whether EWS quota discriminates by exclusion of backward communities, STs, and non-creamy layer OBC communities. The majority view was that it does not violate the Equality Code, that the 103rd Amendment creates a separate class of EWS without affecting the special right of reservations provided to the SC, ST, and non-creamy layer OBCs. The minority views was that yes, it does discriminate, that it's Orwellian in nature, that it was arbitrary, and that exclusion based on social or identity origins strikes at the essence of the non-discriminatory rule. Basically, this amounts to a hostile discrimination of the poorest members of the society who are already socially and educationally backward and subjected to caste discrimination. The court, for the first time in 7 decades of the Republic, according to the minority view, has sanctioned an avowedly exclusionary and discriminatory principle, and further said that our constitution, the Indian constitution, does not speak the language of exclusion. Well, on to the third question of whether the EWS quota breaches the ceiling limit of 50% on reservation. The majority view said no, because the sub-quota is drawn on the already existing 50% that is available for general category, and it is and also that the 50% limit is not inflexible and it only applies to SC, ST, OBCs. The minority opinion said that permitting the breach of the 50% limit would become a gateway for further infractions and result in compartmentalization. Now, this judgment is expected to have far-reaching implications in the field of social justice and electoral politics, hinged as it is in the injustices of identity politics. The bits on reservation going beyond the 50% will especially affect the course of several challenges, legal challenges against reservations in different states, like in the case of Tamil Nadu. This was said by Justice Ravindra Bhatt as well. Now, politically, the BJP and the Congress welcomed the judgment, except, Congress leaders from Tamil Nadu like Karthi Chidambaram, who put on record their differences with their party and they criticized this particular judgment. The BJP has taken credit, in fact, for this judgment, and they say that all ideas that this was basically a move to benefit upper caste candidates was wrong, and that the court has justified the position that the BJP-led government has taken, that it is a move towards equality, that the economically weaker sections among the upper castes also require a sub-quota within the general quota. The DMK, on its part, has kept to a steadfast opposition to the issue and asked for an all-party meet to discuss the implication. Now, what about the Mandal parties, or the parties that grew out of the Mandal Commission report implementation? What about them, the RJD and the Janata Dal, etc.? Well, many of them have demanded or reiterated the demand that this particular judgment, especially when it talks about the 50% limit not being inflexible, basically makes the case for something that they have already been talking about, which is to have a caste census to basically prevent any more hurt feelings. The country needs to know through a caste census how many how many people there are exactly in the OBC category, in the scheduled caste category, in the ST category, etc. And of course, other communities who are also clamoring for reservations, that this would make clear a lot of things and also help in accommodating many interests. There have been apprehensions that the change in the quotas is basically to accommodate demands of basically interest groups, especially during election time, of upper caste groups, and that while this particular economically weaker section quota is carved out of the 50% available for the general category, it may lead to more groups asking for a share, and reservations as a tool for addressing historic oppression through caste society may become a tool for proportional representation, where everyone, rich, poor, backward, forward, has a share amid conflicting claims in terms of conflicting calculations of how much they should be getting. So basically it leaves the door open, according to some people, for such kind of claims to be made. So there is no doubt that this judgment is far-reaching, and it will affect domestic politics, identity politics, especially post-Mandal politics in the Hindi heartland. Already, as I told you, there are demands for a caste census. Nobody is saying that the EWS in itself is bad, which also shows that how far the Mandal politics has changed. But as an antidote, basically there is a demand for a caste census. That demand is now going to be made more and more often. Now we will track this story as and when it pops up again, because it will. And I also want to thank my colleague Krishnadas Rajagopal, who covers the Supreme Court for us, for basically separating the various very complicated schemes of this particular judgment for me. But this is all I have for you this week on this particular subject. I'm sure I will be back with you again on this subject in another context. But for this week, thank you for watching.